Welcome back to Criminal Procedure, CRJU 201A. Today we'll be discussing probable cause and arrests. Today's learning objectives are knowing the difference between an arrest and an investigative stop, understanding probable cause, knowing the requirements to carry out an arrest in a reasonable fashion, understanding arrest warrants, understanding arrest warrants for felonies versus misdemeanors, understanding arrests in the home, knowing exigent circumstances, understanding deadly force, understanding non deadly force, and knowing misdemeanor arrests. An arrest under the Fourth Amendment occurs when an individual is lawfully taken into custody and is more intrusive than a stop and frisk in several ways. While investigative stops usually happen briefly on the street or in public, an arrest involves detention at a police station or jail and can last for hours, days, or longer. Arrests are recorded in a person's criminal history, may involve a full search of the individual and their possessions, and can lead to extended interrogation and formal criminal proceedings. You know you've been arrested either because an officer tells you that you're under arrest or because the circumstances make it clear to a reasonable person that you are in custody, such as being handcuffed, restrained, or involuntarily taken to the station. Key elements of an arrest include the officer acting within their lawful authority, actual restraint of the individual, and an objective understanding that a reasonable person would believe they are under arrest. An arrest under the Fourth Amendment requires probable cause, which is a higher standard than the reasonable suspicion needed for a stop and frisk. Probable cause exists when the facts and circumstances known to an officer, including reasonably trustworthy information, are sufficient for a person of reasonable caution to believe that a crime has been committed and that the individual in question committed it. It is an objective determination based on the totality of the circumstances and practical common sense, not a strict set of rules or mathematical formula. Probable cause is more than mere suspicion, but less than the certainty required for a criminal conviction, and officers may rely on their training and experience in evaluating these facts. Probable cause must be grounded in facts and not intuition or hunches, and can be thought of as an assessment that is more likely than not that the individual committed a crime. The standard balances law enforcement's duty to investigate and apprehend criminals with citizens' privacy interests, ensuring that arrests are neither arbitrary nor excessively burdensome. Officers may establish probable cause using their own observations, the senses, and information from informants or other reliable sources. In United States v. Ortiz, the U.S. Supreme Court observed that Border Patrol officers specifically are entitled to rely on their experience in combating illegal immigration in making a probable cause determination. Again, it's a totality of the circumstances situation which must be assessed to determine probable cause. An officer may rely on their senses to develop probable cause to arrest an individual, including their sight, sound, smell, touch, and even taste in some circumstances, though not often. Direct observations of criminal conduct or behavior characteristic of someone about to commit a crime can establish probable cause, as can hearing a suspect make incriminating statements or confessions. Officers may also seize and analyze scientific evidence such as DNA, fingerprints, or hair samples, and may rely on smells like narcotics or alcohol to support probable cause determinations. In United States v. Humphreys, officers observed a defendant patting his waist, smelled marijuana as they approached him, and followed him when he attempted to flee, all of which the Fourth Circuit found sufficient to constitute probable cause. In Cybron v. New York, visual observations of suspicious behavior, even without witnessing the crime directly, were enough to justify an arrest when combined with contextual facts. Probable cause cannot rely solely on an officer's subjective belief or knowledge of a subject's past criminal record, as the Supreme Court emphasized in Beck v. Ohio, because doing so would allow arrests based on reputation rather than objective facts. In investigations involving multiple officers, courts may apply a collective knowledge theory, under which the knowledge of all officers working together may be combined if there is sufficient communication between them, as in United States v. Gillette, where one officer's awareness was imputed from the knowledge of officers already conducting a lawful search. Probable cause can be based not only on what an officer directly observes, but also on hearsay, which is defined under Federal Rule of Evidence 801C as a statement that the declarant does not make while testifying at the current trial or hearing, offered in evidence to prove the truth of the matter asserted. Hearsay is information reported by someone else, rather than personally witnessed by an officer. This information can come from eyewitnesses, victims, other officers, or informants, but its reliability varies depending on the source. Eyewitnesses and victims are generally presumed credible because they have no apparent motive to lie and are often interviewed soon after the crime occurs. Police officers' reports are also considered reliable, reflecting their training and experience, although their reports are supposed to be made contemporaneously with receiving the information. Informants, however, are treated with skepticism because they may have personal incentives such as reduced charges or other benefits that could bias their information. Courts have developed standards to evaluate whether an informant's tip can support probable cause. In Draper v. United States, an experienced federal agent relied on a paid informant who provided detailed, verifiable information about Draper's travel, appearance, and actions, which the officer personally confirmed. Based on this verification, the court held that the officer had probable cause to believe Draper was carrying heroin. In McCrae v. Illinois, a police informant identified McCrae as possessing narcotics, and the officer verified the informant's reliability and past accuracy, which was sufficient to establish probable cause for arrest. The Supreme Court has also recognized that the government is generally not required to disclose an informant's identity at a probable cause hearing or trial, as doing so could discourage cooperation. Although a judge may require disclosure when the defendant's ability to establish innocence depends on cross-examining the informant. The Aguilar-Spinelli test was the traditional framework used by courts to determine whether information provided by an informant could establish probable cause for a search or arrest. The test is grounded in the principle that a magistrate authorizing a warrant must have sufficient information to independently evaluate the reliability of secondhand information, rather than merely accepting police conclusions. The test requires that an affidavit satisfy two separate prongs: veracity and basis of knowledge. The veracity prong focuses on the credibility of the informant or the reliability of the information provided. Courts look for evidence that the informant has a track record of providing accurate information or that the informant has personal motives that make their report trustworthy. For example, in McCrae v. Illinois, an informant was deemed credible because he had successfully assisted police in previous narcotics investigations. In United States v. Harris, an informant admitted to participating in illegal activity, but provided information to police, which the court considered evidence of reliability because the informant had exposed himself to potential criminal liability, indicating he was unlikely to fabricate certain details. The basis of knowledge prong requires that the affidavit indicate how the informant obtained the information. The magistrate must be able to assess whether the informant had a direct basis for their knowledge, such as witnessing criminal activity or participating in it, rather than merely repeating rumors and speculation. The key is that the information must be more than unverified gossip. It must be grounded in observable or verifiable facts. This prong ensures that the magistrate can independently judge whether the informant's information is likely to be accurate. In Aguilar v. Texas, two police officers obtained a warrant based on an affidavit stating that a credible person had reported that Nick Aguilar was selling narcotics and that drugs were kept at his home. The Supreme Court held that the affidavit did not establish probable cause because it contained only conclusions from the officers and did not provide sufficient detail to show either the informant's credibility or how the informant had obtained the information. The court emphasized that a magistrate cannot rely on conclusory statements. The affidavit must present facts demonstrating both the reliability of the source and the connection between the information and the suspected criminal activity. Justice Goldberg explained that these two prongs, veracity and basis of knowledge, are common sense requirements for any situation in which a court is asked to rely on secondhand information. Spinelli v. United States further clarified the test and illustrated the application of both prongs. In Spinelli, the FBI relied on an anonymous informant and its own investigation to support a warrant to arrest Spinelli for illegal gambling. The affidavit contained several allegations: that Spinelli crossed a bridge several times to enter an apartment in St. Louis, that the apartment had 2 telephones, that Spinelli was known as a bookmaker, and that the informant reported Spinelli was accepting bets via the telephones. The Supreme Court concluded that the affidavit failed both prongs of the Aguilar-Spinelli test. For the veracity prong, there was no information about the informant's reliability or prior track record. For the basis of knowledge prong, the affidavit did not explain how the informant had acquired the information. It did not allege personal observation of gambling or provide details from which the magistrate could infer that the informant was trustworthy. The court stressed that the FBI's corroboration, which consisted primarily of the observation that Spinelli had 2 telephones, was insufficient because this fact was ordinary and did not indicate criminal activity or enhance the reliability of the tip. Spinelli demonstrates that even when the police corroborate minor facts, a warrant can be invalid if the affidavit fails to demonstrate both the credibility of the informant and the basis of their knowledge. By contrast, in Draper v. United States, the Supreme Court upheld a search based on an informant's tip because the officer was able to personally verify almost every detail provided by the informant, such as Draper's appearance, clothing, train arrival time, and the bag he would carry. The court reasoned that the verification of these facts justified the inference that the unverified portion of the tip, that Draper would have heroin, was also likely accurate. Draper illustrates the practical application of Aguilar-Spinelli. Even when a tip is secondhand, if the officer corroborates enough details to show that the informant is credible and that the information was obtained from a reliable source, the affidavit may satisfy both prongs and establish probable cause. The Aguilar-Spinelli test reflects a careful balancing of 2 constitutional concerns: the need for law enforcement to act on information provided by others, particularly informants, and the individual's Fourth Amendment interest in freedom from unreasonable searches and seizures. The test ensures that magistrates can independently evaluate the reliability of an informant's tip rather than relying solely on the officer's judgment. While the Supreme Court later moved on to a more flexible totality of the circumstances approach in Illinois v. Gates, Aguilar-Spinelli remains influential in many states and continues to provide a rigorous framework for evaluating the reliability of informant information, even in a totality of the circumstances analysis. Justice Hugo Black had long criticized the Aguilar-Spinelli test, arguing that it imposed an unnecessarily rigid standard on police officers and magistrates. He contended that the Constitution did not require officers to present facts with such specificity and certainty before being authorized to make an arrest or conduct a search based on probable cause. Black warned that such a strict standard could hinder law enforcement and make it easier for criminals to evade investigation. In 1983, the Supreme Court in Illinois v. Gates formally abandoned the 2-prong Aguilar-Spinelli framework in favor of a more flexible totality of the circumstances approach. In Gates, the Bloomingdale, Illinois police received an anonymous handwritten letter alleging that Sue and Lance Gates were engaged in transporting and selling narcotics. The letter provided a detailed plan discussing how Sue would drive a car to Florida to be loaded with drugs, fly back, and then have Lance return the car to Illinois with over $100,000 in narcotics in the trunk. The letter also stated that the Gateses stored drugs in their basement. Law enforcement corroborated portions of the tip, confirming the couple's address, that Lance was scheduled to fly to Florida on May 5th, and observed the couple's travel patterns. These facts were incorporated into an affidavit, and a judge issued a search warrant for the Gateses' residence and automobile. The search ultimately led to the seizure of 350 pounds of marijuana, weapons, and other contraband. The court recognized that the letter did not satisfy the strict Aguilar-Spinelli 2-prong test because it provided no direct information about the informant's reliability or the basis of knowledge. However, the Supreme Court held that the tip did satisfy the general probable cause standard under a totality of the circumstances analysis. The court emphasized 3 key considerations in concluding that probable cause existed. First, the tip contained detailed predictions about future actions, such as the timing and method of the Gates' drug transport, which were corroborated by police observation. Second, the type of information was consistent with law enforcement's knowledge of drug trafficking patterns, suggesting that the informant had reliable access to information about the Gates' activities. Third, the corroboration of key details by the police enhanced confidence in the accuracy of the tip. The court acknowledged that not all of the information was precise and that some may have been based on rumor, but they stressed that the probable cause analysis requires only a fair probability of criminal activity. The court's adoption of the totality of the circumstances approach reflected a pragmatic recognition that anonymous tips or other informant information may not always meet both Aguilar-Spinelli prongs. The rigid framework had become overly technical and often unworkable in practice. Justices Brennan and Marshall dissented, warning that the totality of the circumstances test provided insufficient guidance to magistrates and risked turning them into rubber stamps for police requests, potentially eroding the Fourth Amendment's protection. Despite the Supreme Court's move away from Aguilar-Spinelli, several state courts, including those in California, Washington, New York, and Massachusetts, have continued to require the two-prong analysis under their own constitutions to provide a stricter check on police authority. The Gates decision illustrates that probable cause is ultimately a practical, common-sense judgment based on the full context of the facts known to the police and the magistrate. It emphasizes that corroboration of key details and consistency with known criminal patterns can compensate for gaps in the informant's demonstrated reliability or basis of knowledge. This approach allows officers to act effectively while still respecting the Fourth Amendment's protection against unreasonable searches and seizures. In District of Columbia v. Wesby, the Supreme Court addressed whether police had probable cause to arrest 21 individuals for unlawful entry into a house in Northeast D.C. Around 1 a.m., police received a complaint from a former neighborhood commissioner about loud music and illegal activity at a house that had been vacant for several months. When officers arrived, neighbors confirmed that the house should be empty. Upon knocking on the door, they saw a man look out a window and run upstairs. One of the partygoers opened the door, and the officers entered, immediately observing that the house was in disarray and resembled a vacant property. Officers smelled marijuana and saw beer bottles and cups of liquor on the floor, which was so dirty that one of the partygoers refused to sit on it. The house had working electricity and plumbing, but contained no furniture downstairs except for a few padded metal chairs, and the only other signs of habitation were blinds on the windows, food in the refrigerator, and toiletries in the bathroom. Inside, the officers discovered that the living room had been converted into a makeshift strip club. Several women were wearing only bras and thongs, with cash tucked into their garter belts while giving lap dances, and most of the other partygoers were holding cash and cups of alcohol. Upstairs, the officers found a naked woman with several men on the only mattress in the bedroom, lit candles, multiple open condom wrappers, and used condoms on the windowsill. Officers located one partygoer hiding in a closet and another who had shut himself in a bathroom. A total of 21 people were present. When interviewed, the partygoers provided inconsistent explanations. Many claimed they were attending a bachelor party, but none could identify the bachelor. Everyone claimed someone had invited them, yet no one could name that person. Two of the women working the party said that a woman named Peaches or Tasty was renting the house and had given them permission to be there. When officers called Peaches, she initially said she had permission but refused to return to the house, claiming she feared arrest. After further questioning, Peaches admitted that she did not have permission to use the house. Officers then confirmed with the owner that Peaches was not a lawful tenant and had no authorization to use the property. Based on these facts, the officers arrested all 21 individuals for unlawful entry. The partygoers were transported to the police station, and a lieutenant decided to charge them with disorderly conduct instead. The charges were eventually dropped. The court emphasized that arrests are seizures under the Fourth Amendment and must be reasonable. Warrantless arrests are justified when officers have probable cause to believe a suspected criminal has committed a crime. Probable cause is assessed objectively based on the totality of the circumstances, which requires only a substantial chance or probability of criminal activity, not certainty. In this case, the court found that the condition of the house, including the near empty rooms, disarray, smell of marijuana, and improvised strip club setup, combined with the partygoers' behavior, created strong inferences that they knew they lacked permission to be there. Their scattering and hiding upon seeing police, implausible explanations for their presence, and Peach's evasive and false statements further supported a reasonable officer's conclusion that the partygoers acted unlawfully. The court criticized the D.C. Circuit Court for analyzing each fact in isolation and for dismissing facts susceptible to innocent explanations. Under the totality of the circumstances standard, officers are not required to rule out innocent explanations. Rather, they evaluate whether there is a substantial chance of criminal activity when all circumstances are considered together. Here, the combination of the house's condition, partygoers' conduct, and unreliable explanations provided ample objective evidence of probable cause. Justice Ginsburg concurred, and she expressed concern about the court's rule that the subjective state of mind of the arresting officer is irrelevant. She noted that Sergeant Suber directed the arrest based on the mistaken belief that the absence of the owner's consent alone justified the arrest, disregarding the requirement that individuals must know or should have known their entry was unauthorized. Ginsburg observed that no officers witnessed behavior supporting a disorderly conduct charge, highlighting the tension between deference to police judgment and protection of Fourth Amendment rights. The holding confirms that probable cause is assessed through an objective, totality of the circumstances lens, and officers may make reasonable inferences based on observable behavior, environment, and corroborated information. The case illustrates how courts weigh multiple factors together rather than dissecting them individually, while Ginsburg's concurrence underscores ongoing concerns about the balance between police authority and individual constitutional protections. In Maryland v. Pringle, a Baltimore County police officer stopped a Nissan for speeding at around 3 o'clock in the morning. The vehicle had 3 occupants: Dante Partlow, who was driving, Jermaine Pringle, seated in the front passenger seat, and Otis Smith, who was seated in the back. When Partlow opened the glove compartment to retrieve his registration, the officer observed a bundle of cash inside. A check of the police computer system revealed no outstanding violations, and the officer issued Partlow a warning. However, thereafter, a second officer arrived at the scene and obtained Partlow's consent to search the vehicle. During the search, officers discovered $763 in cash and several envelopes containing cocaine concealed behind the back seat armrest. All 3 occupants refused to provide any information regarding ownership of the money or the drugs, and each was placed under arrest. Pringle later confessed that the drugs belonged to him and claimed that Partlow and Smith were unaware of their presence. He was convicted of cocaine possession and sentenced to 10 years in prison. On appeal, Pringle argued that his arrest was unsupported by probable cause and that his subsequent confession should have been suppressed. The Supreme Court rejected this argument. They emphasized that probable cause cannot be reduced to a precise formula. Instead, probable cause exists when there is a reasonable ground to believe that a crime has been committed and a reasonable belief that a particular individual committed that crime. Viewing the facts from the perspective of a reasonable officer, the court concluded that it was an entirely reasonable inference that any or all of the occupants had knowledge of and exercised dominion and control over the cocaine. The drugs were located in a common area of the vehicle, none of the occupants claimed ownership, and the presence of both cash and packaged narcotics supported the inference of a shared enterprise. The court reasoned that individuals engaged in drug trafficking are unlikely to include an innocent outsider who might later testify against them. Under these circumstances, a reasonable officer could conclude that there was probable cause to arrest Pringle, either alone or as part of a joint criminal undertaking. The court's conclusion in Pringle contrasts sharply with its earlier decision in United States v. DeRee. In DeRee, Reed informed an employee of the U.S. Office of Price Administration that he had arranged to purchase counterfeit gasoline ration coupons from Butita during World War II. Police followed Butita's car and approached it during the transaction, discovering Reed holding 2 counterfeit coupons. Reed stated that he had purchased the coupons from Butita. Reed and Butita were arrested, along with DeRee, who was seated in the front passenger seat next to Butita. Although DeRee was later found to be carrying approximately 100 counterfeit coupons concealed beneath his clothing, the Supreme Court held that his arrest was not supported by probable cause. The court reasoned that DeRee's presence in the vehicle did not establish that he knew of the transaction or that he knew the coupons were counterfeit. Reed explicitly identified Butita as the seller, and the exchange occurred in broad daylight on a public street, where the passing of papers was not obviously criminal. The court emphasized that presumptions of guilt cannot be lightly inferred from mere association or proximity to criminal activity and reversed DeRee's conviction. The different outcomes in Pringle and DeRee reflect the court's focus on the totality of the circumstances analysis. In Pringle, the drugs and cash were hidden in a shared space, the occupants denied ownership, and the surrounding circumstances suggested that a common criminal enterprise was underfoot. In DeRee, by contrast, the crime appeared discrete and individualized. The informant singled out a specific culprit, and nothing about DeRee's presence alone reasonably indicated his participation. The cases together illustrate that probable cause depends not upon guilt by association, but on whether the surrounding facts reasonably support an inference of shared knowledge or joint criminal activity. I'm going to make a slight correction here to your book. In February of 2020, Ahmaud Arbery, who was an unarmed African American jogger, was pursued and killed by 3 white men who were charged with multiple state offenses, including felony murder, as well as federal hate crime and firearms offenses. The defendants claimed their actions were justified under Georgia's citizen's arrest law, arguing that they suspected Arbery of burglary and were attempting to detain him. At the time, Georgia's citizen arrest statute, adopted in 1863, allowed a private person to arrest someone for an offense committed in the person's presence or immediate knowledge, and to arrest a suspected felon attempting to escape upon reasonable and probable grounds of suspicion. Georgia courts had recognized that reasonable force could be used in carrying out such a detention. There were no arrests until after 2 months, and no charges until May of 2020. Following his killing, Georgia repealed its citizen's arrest law through the Ahmaud Arbery Act, eliminating detention authority for ordinary witnesses and bystanders and limiting it to certain business and security contexts. The jury went on to reject the defendant's citizen arrest defense, and the defendants, who I won't bother to name here, were convicted of felony murder and later of federal hate crimes. Their request for a retrial was denied. The Fourth Amendment requires not only that arrests be supported by probable cause, but also that they be carried out in a reasonable manner. Courts have identified several recurring issues in evaluating the reasonableness of arrests, including the circumstances under which warrants are required, when arrests may be made without a warrant, and the special protections that apply to arrests inside a person's home. The law also recognizes an exigent circumstances exception that may justify a warrantless home arrest in limited situations. Additionally, officers are permitted to use only reasonable force when making an arrest, and states and local governments may authorize arrests for misdemeanors or allow officers to issue citations instead of making custodial arrests. The Supreme Court has almost always expressed a preference for arrests to be made pursuant to an arrest warrant, because a warrant reflects a prior determination of probable cause rather than a hurried judgment made in the field by a police officer. To obtain a warrant, officers must present facts under oath to a judge or magistrate, who then makes a determination that there's a fair probability that a crime has been committed and that the person named committed it. This process is intended to protect individual liberty by ensuring that the intrusive act of arrest is justified by evidence reviewed by an independent official. The Fourth Amendment requires that warrants issue only upon probable cause, supported by an oath or affirmation. Probable cause must be established before a neutral, judicial official capable of making an independent judgment, typically a judge or a magistrate. A valid arrest warrant must particularly identify the person to be arrested, the offense charged, and the relevant circumstances, and it must be supported by a sworn affidavit from an officer setting forth the facts establishing probable cause. Although the warrant process is not adversarial, the judicial official must independently determine whether probable cause exists, including in situations where warrants are requested by telephone or other electronic means. Defendants may later challenge the validity of an arrest warrant on several grounds, including that it was not supported by probable cause, that the supporting affidavit contained knowingly false statements, and that the warrant was issued through improper procedures. The Supreme Court has made clear that warrants issued by prosecutors or police officers are invalid, and that financial incentives or lack of neutrality on the part of the issuing judicial official violate the Fourth Amendment. When an arrest is made without a warrant, the probable cause standard is the same as for a warrant-based arrest. However, once a suspect is taken into custody, the justification for bypassing judicial review disappears. The Supreme Court held in Gerstein v. Pio that individuals subjected to extended detention are entitled to a prompt judicial determination of probable cause, and in County of Riverside v. McLaughlin, the court clarified that this determination generally must occur within 48 hours of arrest, absent extraordinary circumstances. Although the Supreme Court has expressed a preference for arrests based on warrants, the vast majority of arrests occur without them. In United States v. Watson, the court recognized that requiring warrants in all cases could unduly slow law enforcement. In Watson, federal postal inspectors arrested Henry Ogle Watson in public without a warrant based on probable cause that he possessed stolen credit cards, relying on a federal statute authorizing warrantless felony arrests. Watson argued that the arrest and subsequent search violated the Fourth Amendment, but the Supreme Court rejected his claim, holding that warrantless public arrests for felonies supported by probable cause are consistent with long-standing common law practice and with state and federal law. The court emphasized that while warrants are preferred, the Constitution does not require them for public felony arrests, even when officers have time to obtain a warrant. The court has treated misdemeanor arrests somewhat differently. In Atwater v. Laga Vista, the Supreme Court addressed whether police may make a warrantless arrest for a misdemeanor and concluded that such arrests are constitutionally permissible when the offense is committed in the officer's presence. Justice Souter explained that centuries of common law practice support warrantless misdemeanor arrests only under this condition. An offense is considered committed in the presence of an officer when the officer personally perceives each element of the crime through one of the five senses, or when the suspect admits the offense and the arrest must be made promptly. Courts have strictly enforced this requirement. For example, a California court held that an officer lacked authority to arrest a juvenile for inhaling paint fumes because the officer did not actually observe the act itself, even though the juvenile showed signs that the conduct had occurred earlier. Atwater confirms that police may make warrantless arrests for misdemeanors committed in their presence, but it leaves unresolved the constitutional status of warrantless arrests for misdemeanors committed outside an officer's presence. Lower courts have questioned whether the Fourth Amendment permits such an arrest, and many state legislatures have responded by authorizing warrantless arrests for specific misdemeanors such as domestic violence, shoplifting, and drunk driving, even when the officer did not witness the offense. In short, although arrest warrants are preferred, the Supreme Court has made clear that warrants are not constitutionally required for public arrests based on probable cause for felonies or for misdemeanors committed in an officer's presence. The analysis changes, however, when an arrest takes place inside a home, where warrants are generally required unless there are exigent circumstances. The Supreme Court emphasized that the home occupies a special place under the Fourth Amendment, explaining that the physical entry into the home is the chief evil against which the amendment was directed, and that the Constitution draws a firm line at the entrance to the home. Requiring an arrest warrant for in-home arrest protects the privacy and security of individuals against unjustified intrusions by the government. However, some courts have been split based on common areas that may otherwise fall outside or near the boundary of a home. Some courts treat arrests made when a suspect opens the door as arrests occurring inside the home, requiring a warrant, while others conclude that if the officer remains outside and does not cross the threshold, the arrest is effectively public and no warrant was required. Courts also disagree when a suspect exits the home in response to police commands and is then arrested, with some viewing this as a constructive entry that triggers the warrant requirement. By contrast, arrests made in common hallways of apartment buildings are generally considered public and do not require a warrant. Hotel and motel rooms, however, are treated like homes for Fourth Amendment purposes, and an arrest warrant is required to arrest a guest inside a rented room. In Peyton v. New York, 445 U.S. 573, 1980, the Supreme Court addressed whether the Fourth Amendment permits police officers to enter a private residence without a warrant and with force, if necessary, to make a routine felony arrest. The court noted that although it had approved warrantless public felony arrests in United States v. Watson, it had expressly left unresolved whether officers may enter a suspect's home to make a warrantless arrest. The case consolidated two prosecutions under New York statutes authorizing warrantless home arrests. In Peyton's case, officers forcibly entered his apartment without a warrant after developing probable cause to believe he had committed murder, seized evidence in plain view, and later used it at trial. In Riddick's case, officers entered his home without a warrant after his son opened the door, arrested him for armed robbery, and seized narcotics from nearby furniture. New York courts had upheld both arrests under state law. Writing for the court, Justice Stevens emphasized that the Fourth Amendment was designed not only to regulate warrants, but more broadly to protect against unreasonable searches and seizures, particularly intrusions into the home. The court reiterated that physical entry into the home is the chief evil against which the Fourth Amendment is directed, and that searches and seizures inside a home without a warrant are presumptively unreasonable. The court rejected the argument that arrests are meaningfully less intrusive than searches, reasoning that both involve the same fundamental invasion of privacy, the breach of the home's threshold, and therefore warrant the same level of constitutional protection. Although historical practice and state statutes varied, the court concluded that neither common law nor modern experience justified abandoning the strong constitutional protection afforded to the home. Policy arguments about law enforcement efficiency were deemed insufficient to override what the court viewed as a clear constitutional command. The court held that absent consent or exigent circumstances, the Fourth Amendment requires police to obtain an arrest warrant before entering a suspect's home to make a felony arrest. An arrest warrant founded on probable cause implicitly authorizes limited entry into a dwelling in which the suspect lives when there is reason to believe that the suspect is inside. Because no warrants were obtained in either Peyton or Riddick's case, the judgments were reversed and remanded. Justice White dissented, arguing that the court's rigid rule lacked support in the text, history, and common law background of the Fourth Amendment. He maintained that at common law, officers possessed broad authority to enter homes to make felony arrests, subject to significant limitations such as felony requirement, knock and announce rules, daytime entry, and strong probable cause. In his view, these safeguards adequately protected privacy interests and rendered warrantless home arrests no more intrusive than warrantless public arrests approved in Watson. The dissent warned that the majority's rule would severely hamper effective law enforcement by forcing officers to make difficult, time-sensitive judgments about exigency and risking either suppression of evidence or the escape of dangerous suspects. In Stigall v. United States, 451 U.S. 204, 1981, the Supreme Court addressed whether police may enter the home of a third party to execute an arrest warrant for a suspect believed to be inside. DEA agents entered Gary Stigall's home with an arrest warrant for Ricky Lyons, a fugitive wanted on federal drug charges, and discovered cocaine during the search. Stigall moved to suppress the evidence, arguing that the entry violated the Fourth Amendment. The court held that an arrest warrant for a suspect does not authorize entry into the home of a third party. Instead, officers must obtain a search warrant to enter the third party's residence. Although both arrest and search warrants require probable cause, the court emphasized that they protect different constitutional interests. An arrest warrant safeguards an individual against unreasonable seizure, while a search warrant protects the privacy interests of people in their homes by requiring probable cause that the object of the search is located in a particular place. The court concluded that the additional burden of obtaining a search warrant is outweighed by the right of presumptively innocent third parties to be secure in their homes from unjustified police intrusion. Because the agents had advance notice and sufficient time to obtain a search warrant for Stegall's home, the warrantless entry was unconstitutional. The court also warned that allowing arrest warrants to justify searches of third-party homes would permit police to search the residences of suspects' friends, relatives, and acquaintances without adequate judicial oversight. In Peyton v. New York, the Supreme Court held that arrests inside a home without a warrant are presumptively unreasonable, unless there is consent or exigent circumstances. Exigent circumstances involve situations where law enforcement faces an urgent need to act immediately. The court has recognized several circumstances that may justify warrantless entry into a home. One such circumstance is hot pursuit. If police are pursuing a suspect who flees into a home, they may enter without a warrant to prevent the suspect from evading arrest. In United States v. Santana, for example, police followed a suspect into her home to arrest her for drug possession and to avoid the immediate threat that she may destroy narcotics. The court upheld that a suspect cannot avoid arrest simply by retreating into a dwelling. Another recognized exigency is public safety. Police may enter a home without a warrant if they reasonably believe that immediate action is necessary to protect the public. In Michigan v. Tyler, the court upheld warrantless entry into a burning building, noting that the urgent need to combat the fire made the entry reasonable. A third type of exigency involves the destruction of evidence, like we saw in hot pursuit. Officers may enter a home without a warrant if waiting to obtain one would allow a suspect to destroy or dispose of evidence. In Kerr v. California, police acted quickly to enter an apartment where they believed narcotics were being sold, ensuring that the evidence could not be destroyed. A fourth circumstance is the risk of flight. Police may enter without a warrant if they reasonably believe that a suspect is likely to flee the jurisdiction. In United States v. Gaetan Acevedo, federal officers entered a hotel room to arrest a drug courier because they feared that others who had not yet been arrested would destroy evidence or flee. Courts determine whether exigent circumstances exist by examining whether the police had probable cause and whether they reasonably believed that immediate action was necessary. As the Third Circuit explained in United States v. Rubin, the crucial question is whether the officers acted on the spur of the moment and could not have obtained a warrant in time. Exigent circumstances, however, are not limitless. In Welsh v. Wisconsin, 466 U.S. 740, 1984, the Supreme Court addressed whether the Fourth Amendment allows police to enter a home at night without a warrant to arrest a person for a non-jailable traffic offense. Peyton v. New York had already established that warrantless home arrests are presumptively unconstitutional unless supported by probable cause and exigent circumstances. However, Peyton did not define what constitutes exigent circumstances. Welsh presented the question of whether a minor offense like a first-time non-criminal DUI could ever justify a warrantless home entry. On the night of April 24, 1978, a witness observed a car being driven erratically. The car eventually went off the road and stopped in a field. No damage occurred. The witness tried to prevent the car from returning to the road and asked another passerby to contact the police. The driver walked away from the scene. Police later determined that the car was registered to Edward G. Welsh, whose home was nearby. Without a warrant, officers went to his home around 9 p.m., entered when his stepdaughter answered the door, and found Welsh in his bedroom. He was arrested for driving while intoxicated, a first offense classified under Wisconsin law as a non-criminal civil violation, punishable only by a monetary fine. The trial court upheld the arrest, citing probable cause and exigent circumstances. The appellate court disagreed, holding that the warrantless home arrest violated the Fourth Amendment because no exigent circumstances were shown. The Wisconsin Supreme Court reversed, pointing to three factors it considered exigent: hot pursuit, danger to public safety, and preservation of evidence, the BAC level. The U.S. Supreme Court granted cert to resolve the constitutional issue. The court reiterated that the home is the chief evil targeted by the Fourth Amendment, and that warrantless entries are presumptively unreasonable. Exceptions are rare, carefully delineated, and the government bears a heavy burden in proving urgency. Prior cases recognized exigencies such as hot pursuit, imminent destruction of evidence, and immediate danger to life. But these exceptions are applied cautiously, especially for minor offenses. When considering the facts of Welsh, the court found no hot pursuit because he had already returned home, and the abandoned car posed no ongoing public threat. The only claimed exigency was preserving blood alcohol evidence. However, the minor nature of the offense, a first-time civil DUI violation, meant that the presumption of unreasonableness for a warrantless home entry could not be overcome. Officers should generally rely on a magistrate-issued warrant in such situations. Lower courts frequently consider the gravity of the underlying offense when evaluating exigent circumstances. It is difficult to imagine a warrantless home arrest being reasonable when the offense is so minor. The court emphasized that application of exigent circumstances should rarely be allowed for minor offenses, even when probable cause exists. The court clarified that warrantless in-home arrests designed to prevent the imminent destruction or removal of evidence of a minor offense are always impermissible. Tests that tie exigent circumstances to the perceived gravity of the offense would create unnecessary litigation and hamper police operations. Officers in the field often lack the time or competence to assess whether an offense is serious enough to justify a warrantless home entry. However, the court recognized that for serious offenses, the imminent destruction of evidence could justify a warrantless home arrest. For example, alcohol levels in the blood begin to diminish naturally over time, and a suspect could potentially consume more alcohol if not promptly arrested. In such cases, rapid police action could constitute a valid exigency. In Welsh's case, though, the offense was minor, and no exigent circumstances justified the home entry. The Supreme Court held that the warrantless home arrest of Edward Welsh was for a non-criminal first offense DUI violated the Fourth Amendment. The gravity of the underlying offense is a crucial factor in determining whether exigent circumstances exist. Minor offenses generally cannot justify warrantless home entries, and the presumption of unreasonableness should prevail unless a serious offense and true exigency are present. In Lang v. California, 594 U.S. 295, 2021, the Supreme Court addressed whether police pursuing a suspect for a misdemeanor are automatically justified in entering a home without a warrant under the hot pursuit doctrine. Arthur Lang was driving home when Officer Aaron Weichert began following him because Lang was allegedly playing music very loudly and repeatedly honking his horn. As Lang pulled into his garage, Weichert turned on his lights and pursued him inside. Once inside, Weichert detected the smell of alcohol, administered field sobriety tests, and arrested Lang. Lang's blood alcohol content level later tested at 0.245%, over 3 times the legal limit. Lang argued that his Fourth Amendment rights were violated because the police entered his home without a warrant. The court considered whether or not the hot pursuit of a suspect for a misdemeanor automatically justified a warrantless home entry under the Fourth Amendment. Justice Kagan, writing for the majority, rejected a categorical rule allowing warrantless entry for misdemeanors. Instead, she emphasized a case-by-case approach. The key question is whether the circumstances demanded immediate action or whether the police could reasonably have obtained a warrant. The court recognized that exigent circumstances may exist if there is imminent harm to others, threat to the officer, destruction of evidence, or escape from the home. Flight alone, pursuing a suspect, does not automatically justify entering a home without a warrant, particularly for minor offenses. Justice Kagan stressed the need to balance law enforcement interests against the Fourth Amendment protection of the home. Chief Justice Roberts, joined by Justice Alito, expressed concern that Kagan's decision could endanger officers and create uncertainty. He argued that prior precedent established a general rule that hot pursuit justifies a warrantless entry. Roberts worried that requiring officers to evaluate the gravity of the offense in real time is impractical. The emergency aid doctrine permits officers to enter a residence without a warrant to provide immediate assistance to someone who is seriously injured or faces imminent harm. In Brigham City v. Stewart, the Supreme Court addressed this issue. In that case, police responded around 3:00 a.m. to a complaint about a loud party. When they arrived, they heard shouting, crashing, and thumping from inside the home. Looking through a window, and a screen door. They saw 4 adults restraining a juvenile in a violent struggle. The juvenile hit one of the adults, drawing blood, and the adults pressed the juvenile against the refrigerator, moving it across the floor. The officers announced their presence, but the struggle continued, so they entered the home to stop the altercation. The court held that the officers' entry was justified under the emergency aid doctrine. The need to prevent serious injury or to render assistance to someone at risk constitutes a valid exigency that overrides the usual warrant requirement. The court emphasized that the test is objective, focusing on whether a reasonable officer could conclude that immediate action was necessary. The court also made clear that it does not matter if the officer's subjective motivation was to make an arrest rather than to render assistance. The seriousness of the situation is a key factor, which distinguishes Brigham City from cases like Welsh v. Wisconsin, where the only claimed emergency was the potential dissipation of blood alcohol evidence. The Supreme Court reaffirmed this approach in Michigan v. Fisher. In that case, the court held that officers do not need perfect information. They only need an objectively reasonable basis to believe that someone requires immediate help or faces danger. This principle was extended in Ryburn v. Huff, where police responded to a report that a student threatened to shoot up his school. The officers initially contacted the student's mother by phone, but she hung up on them. Later, she refused to allow police into the home. Fearing for their safety and the safety of others inside, the officers entered the home. The Supreme Court held that the entry was reasonable because exigent circumstances must be evaluated based on the totality of the circumstances, and courts should not second-guess split-second decisions made under tense, uncertain, and rapidly evolving conditions. In summary, the emergency aid doctrine allows a warrantless entry where there is a need to prevent serious injury or death. The evaluation is objective and considers whether a reasonable officer would conclude that immediate action was necessary. This includes concerns for officer safety and the safety of occupants inside the home. Split-second decisions made in rapidly evolving situations are judged based on the circumstances at the time, not with hindsight. Unlike cases such as Welsh, which involved minor, non-criminal offenses, the no immediate threat to life or safety cases like Brigham City and Ryburn demonstrate circumstances where immediate entry is justified. Ultimately, the emergency aid doctrine is an important exception to the Fourth Amendment warrant requirement because it balances individual privacy with the need to protect life and prevent serious injury. In Kentucky v. King, the Supreme Court addressed the limits of the exigent circumstances doctrine and whether the police can rely on it when they are in hot pursuit of evidence. In this case, police arranged a controlled buy of crack cocaine outside an apartment complex. An undercover officer observed the transaction from an unmarked car and radioed uniformed officers to hurry up and get there before the suspect entered his apartment. When the uniformed officers arrived, they heard a door shut and detected the strong odor of burnt marijuana, but they could not tell which of the 2 nearby apartments the odor was coming from. Smelling marijuana from the left-hand apartment, the officers approached the door, loudly announced "Police, police, police," and heard movement inside. Believing that drug evidence was about to be destroyed, the officers kicked in the door and seized the drugs, cash, and paraphernalia. They later entered the apartment on the right and arrested the suspected drug dealer. The occupants argued that the evidence should be suppressed under the police-created exigency doctrine, which holds that officers cannot rely on exigent circumstances if they themselves created the emergency. The Supreme Court, however, rejected this claim. The court found that the police acted lawfully because they announced their presence, waited for a response, and only entered when they had probable cause to believe evidence was being destroyed. The court emphasized that the occupants themselves created the exigent circumstances by attempting to destroy the drugs. At the same time, the court cautioned that exigent circumstances cannot be claimed if the police violate the Fourth Amendment in creating the situation. For example, it would be unreasonable for officers to break down a door, threaten entry, or otherwise coerce access, and then argue that exigent circumstances justified the warrantless entry. In King, no such police misconduct occurred, so the search was upheld. The case clarifies that the exigent circumstances exception allows warrantless entry only when the emergency arises independently of police misconduct, and that the Fourth Amendment still protects against situations where the police manufacture an emergency to justify entry. However, I will clarify that there is still hotly contested debates in the various circuits about whether or not a police manufactured emergency is enough to justify entry. Eventually, the Supreme Court's going to have to take this one back up and really clarify their position. In Missouri v. McNeely, Tyler McNeely was stopped for speeding and repeatedly crossing the center line. He showed signs of intoxication and performed really poorly on his field sobriety tests. McNeely refused a portable breath test, and he was placed under arrest and taken to a hospital for a blood test. He again refused, even after being warned that refusal could result in his license being revoked and could be used against him in court. A medical technician drew blood at the officer's direction, and the test showed a BAC level of 0.154, which was well above the legal limit of 0.08. The trial court suppressed the blood test because no search warrant had been obtained. The Supreme Court rejected a categorical rule allowing warrantless blood draws in drunk driving cases, holding that the natural dissipation of alcohol in the blood does not automatically create an exigency that eliminates the Fourth Amendment's warrant requirement. Justice Sonia Sotomayor emphasized that while alcohol levels decrease over time, advances in technology now allow officers to obtain warrants more quickly, often without undermining the investigation. Whether a warrantless blood draw is reasonable must therefore be evaluated on a case-by-case basis based on the totality of the circumstances, including practical considerations of obtaining a warrant in time to preserve the reliable evidence. In Mitchell v. Wisconsin, Gerald Mitchell was found by police wet, shirtless, slightly sandy, and slurring his words, and highly intoxicated. A preliminary portable breath test indicated a BAC 3 times the legal limit, but the test was unreliable and could not be used in court. Police took Mitchell to the hospital where he passed out, and a blood sample was drawn, showing a BAC of 0.22. Justice Alito, writing for the plurality, held that a warrantless blood draw was justified under these exigent circumstances because Mitchell's stupor and eventual unconsciousness prevented a reliable breath test and left police with no reasonable opportunity to obtain a warrant without losing the evidence. Alito emphasized that alcohol in the blood is literally disappearing by the minute, and that the time needed to obtain a warrant could impede the state's compelling interest in enforcing drunk driving laws, which are linked to a high number of fatalities. The court noted that the unconscious state of a driver adds practical challenges, including transportation, medical care, and evidence preservation, further supporting the reasonableness of a warrantless blood draw in these circumstances. If you, like me, were wondering what's the difference and why does it matter, the court in Mitchell cited to McNeely multiple times. Ultimately, the court found that the exigency in Mitchell was higher due to Mitchell's unconscious status. It really, truly did have to do with the fact that there were many things the officers were going to have to do that they didn't have to do in McNeely, like secure the transportation to the hospital and take care of Mitchell in his unconscious state. Together, McNeely and Mitchell illustrate that the Fourth Amendment generally requires a warrant for a blood draw, but exigent circumstances can justify a warrantless search when obtaining a warrant would be impractical and evidence is at an imminent risk of being lost, such as when the suspect is unconscious or cannot provide a reliable breath test. Federal and state courts recognize the community caretaker doctrine, which allows police to act to protect the public or individuals from harm, independent of criminal investigations. In State v. Kramer, a Wisconsin officer pulled over when he saw Todd Kramer's pickup truck, which was pulled over on the side of the road with hazard lights flashing, to check if he needed assistance. The officer observed signs of intoxication, including slurred speech and the smell of alcohol. The officer arrested Kramer for DUI. The court held that the officer acted in a valid community caretaker role because the action was totally divorced from investigating a crime, and the public interest in safety outweighed the intrusion into Kramer's privacy. For a community caretaker action to be valid, 2 requirements must be met. The activity must be a bona fide caretaker function, unrelated to criminal investigation, and the public need must outweigh the intrusion on privacy. In Kramer, checking on a potentially stranded driver clearly met both criteria. The Supreme Court addressed similar issues in Caniglia v. Strom. Edward Caniglia left a loaded gun on the dining room table and asked his wife to shoot him. She left for safety and called the police for a welfare check. Officers, fearing that he posed a risk to himself and others, called an ambulance and seized the weapon after he agreed to go to the hospital. Justice Thomas noted that while Katie v. Dombrowski recognized community caretaker functions on public highways, it did not authorize warrantless entries into homes. The court remanded the case to determine whether exigent circumstances, not the caretaker doctrine, justified the entry. These cases show that police may act to protect individuals under the community caretaker doctrine, but the doctrine is limited inside homes, and courts weigh public need against intrusion on privacy. One of the most controversial areas addressed by courts surrounding the amount of force to use in an arrest is the use of deadly force to apprehend a fleeing suspect, which effectively imposes a fatal punishment without a trial. Historically, up to the 14th century, police could use deadly force against felons, even if non-lethal apprehension was possible. This was justified by the belief that felons, being lawless and subject to capital punishment, had forfeited their right to life. In contrast, only reasonable force could be used against misdemeanors, as minor offenses posed with little threat and did not warrant death. The fleeing felon rule permitted police to use deadly force against a fleeing felon. Some states limited this by holding officers liable if it was later shown that the use of deadly force was mistaken. By the 1980s, courts began to question the rule overall. Few felonies were punishable by death, many offenses were nonviolent, and policing had changed with firearms and modern procedures. The rule had also historically allowed private citizens to employ deadly force with criminal liability only if mistaken, which wasn't a great rule. The Supreme Court addressed these issues in Tennessee v. Garner in 1985. The court rejected the idea that probable cause alone justified deadly force. Instead, it held that deadly force is constitutionally permissible only when the officer has probable cause to believe the suspect poses a serious threat to the officer or others. The court thus balanced the suspect's constitutional rights against society's interest in apprehending felons, emphasizing that split-second decisions by officers must still respect the Fourth Amendment. Critics question whether judges and juries, often relying solely on police testimony, can fairly evaluate the pressures faced by officers. Others argue that Garner provides an important check on police authority. The case underscores the ongoing tension between protecting individual rights and allowing law enforcement to act effectively, raising the question of whether the standard strikes the right balance. Just by way of information, the number of individuals who have been killed by police officers has surpassed 1,000 in October of 2025. The final numbers haven't been released yet, but if they've been released by the time we get to this section, I'll post it in the announcements. In Tennessee v. Garner, the Supreme Court addressed the constitutionality of using deadly force to prevent the escape of a fleeing suspected felon. The facts involved a 15-year-old, Edward Garner, who was fleeing a suspected burglary. Officer Hyman, believing Garner to be unarmed, shot him as he attempted to climb a fence, killing him. Tennessee law at the time allowed police to use all necessary means to effect an arrest of a fleeing felon, and the Memphis Police Department policy permitted deadly force in burglary cases. The court emphasized that any seizure, including deadly force, must satisfy the Fourth Amendment's reasonableness requirement. Probable cause to arrest a suspect does not automatically justify killing that suspect. The court balanced the suspect's interest in life against the government's interest in law enforcement and concluded that the intrusiveness of deadly force is extreme. While shooting nonviolent suspects does not significantly advance public safety or the effectiveness of law enforcement. The court held that deadly force may only be used if the officer has probable cause to believe the suspect poses a threat of serious physical harm to the officer or others, or has committed a violent felony. Otherwise, the use of deadly force is unreasonable. Burglary, while serious, is primarily a property crime and does not automatically justify deadly force. Statistics show most burglaries do not involve violence. Officer Hyman's actions were therefore unconstitutional, as Garner was unarmed, non-dangerous, and fleeing. The dissent by Justice O'Connor argued that burglary, especially at night, presents serious risks of harm, and the officer could not know the circumstances inside the home. She contended that the reasonableness of deadly force should account for the seriousness of the crime and the inherent risk. The dissent warned that the majority's decision effectively grants a right to flight for burglars. Ultimately, Garner established the rule that police may not use deadly force against unarmed, non-dangerous suspects to prevent escape, making a critical limitation on the old fleeing felon rule and reinforcing the constitutional protection of life in the context of the Fourth Amendment seizure. Here in just a few minutes, we're going to turn to a discussion about non-deadly force. The Supreme Court in Graham v. Connor clarified that claims of excessive force, whether deadly or non-deadly, are supposed to be evaluated under the Fourth Amendment's objective reasonableness standard and based on a totality of the circumstances. However, before we get to Graham, I want to discuss a personal example from my time at the prosecutor's office. And while I'm telling you this story, I want you to think about what I considered from this case, which was whether or not the use of officer force hampered my prosecution of the criminal case. So I'm going to call the defendant in my case John Doe. John Doe was a shorter individual. He was about 5'2". He was about 130 pounds, and he was a sovereign citizen. If you don't know what a sovereign citizen is, I encourage you to look it up on YouTube. Watch some videos of officers interacting with sovereign citizens. What you need to know for this story is that sovereign citizens do not respect police authority. They don't think they're bound by the laws of any state or nation. And they rely on the Magna Carta as the document that gives them this authority to basically ignore all of the rest of our laws as a nation and a society. So you can probably imagine somebody who feels that way probably doesn't interact well with the police. So John Doe was wanted for a different crime, and he had a warrant out for his arrest. And the officers who were working the case were driving around and they recognized him from prior interactions, and they picked John Doe up on his warrant. And so when the police got out of their cars and John Doe witnessed them, he immediately became defensive and aggressive with officers. And rather than just, accepting that he was picking up on the warrant and that he was going to be going to jail, he decided to have a scuffle with the officers. You might wonder why I bothered to tell you his height and weight. The reason is because the arresting officer is about 6'5" and just made of muscle. Huge, huge individual, very large man. And when we watched back the video from the dash cam and from the body camera, the footage didn't look great. Sure, John Doe was resisting arrest, certainly putting up a fight against this officer, but not putting up much of a fight. He didn't really have a chance, frankly. And so when we came time for trial, we were trying to make a decision because there were two counts that John Doe was being charged with. He was being charged with resisting law enforcement, and he was being charged with possession of marijuana. The possession of marijuana could have won that all day. He had the marijuana, it was in his pocket. The defense of those aren't my pants is not a very good defense for possession of marijuana. That one was not really in dispute. However, what was in dispute was whether or not the defendant, John Doe, had resisted law enforcement and whether or not his resistance justified the amount of force that the officer working the case used to arrest him. And to his credit, defense counsel brought that up relentlessly. He multiple times brought up the size difference between the arresting officer and John Doe. And eventually the jury went back and deliberated. And the jury decided, yeah, no, you're right. That wasn't fair, is essentially what they came back with. The jury said they just couldn't understand how this huge officer had such a hard time wrangling this tiny man who's about 5'2" and 130 pounds. And they said that the amount of force that he used made them uncomfortable. And therefore, they didn't feel comfortable convicting this small defendant of resisting law enforcement. And was it ultimately the legally correct decision? No. The defendant absolutely resisted the officers. He refused to put his arms behind his back. He wouldn't be handcuffed. He technically resisted law enforcement. But the jury looked at it, and the defense attorney argued in a very compelling manner that the officer's use of force to arrest this guy was disproportional to the size of the individual and also to the relation of the charges he was being faced with there. Something you wouldn't necessarily know, but we're not allowed to bring up the prior cases and the thing he was being picked up on for a warrant. You're not allowed to bring those up in criminal trials. So, as far as the jury knows, he was just being charged with the possession of marijuana. And they thought the amount of force that was being used for the possession of marijuana was way too much. It was a very good learning experience as a young prosecutor to see that. And it's not entirely relevant. But as we go into the next couple of cases, I just want you to really think about, yeah, non-deadly force, we're going to discuss the constitutionality of it and how much force is too much force. But I also want you to think about it from a practical perspective. Does an officer using too much force hamper a prosecutor's ability to get a conviction on the charges that have been charged in the case? Does it look bad to a jury? Is it too much, whether constitutionally or just in reality to the jury? In Graham v. Connor, 490 U.S. 386, 1989, the central issue was what constitutional standard applies when a citizen claims that police used excessive force during an arrest, investigatory stop, or other seizure. The Supreme Court held that all such claims, whether involving deadly or non-deadly force, are governed by the Fourth Amendment's objective reasonableness standard, not by a broader substantive due process approach. In this case, on November 12, 1984, DeThorne Graham, a diabetic, experienced an insulin reaction and asked a friend to drive him to a store for some orange juice. He saw a long line, and so he left the store and asked to be driven to a friend's house instead. Officer Connor observed Graham leaving hastily and suspected that he'd done something wrong. Therefore, he decided to conduct an investigative stop. The situation quickly escalated. Graham ran around the patrol car, passed out, and multiple officers ultimately used physical force, including throwing him headfirst into a police car, causing injuries. Graham sued under 42 U.S.C. Section 1983, claiming the officers used excessive force in violation of his constitutional rights. The district court granted the officers a directed verdict, finding their actions were in good faith and aimed at maintaining order. The Fourth Circuit affirmed, but the Supreme Court granted cert to review the proper standard. The court emphasized that claims of excessive force in the context of an arrest or seizure implicate the Fourth Amendment's protections against unreasonable seizures, not a general substantive due process right. The evaluation of force must consider the totality of the circumstances, balancing the nature and severity of the intrusion on the individual and the governmental interest, including the need to effectuate the arrest or investigatory stop. Relevant factors include the seriousness of the suspected offense, whether the suspect poses an immediate threat, and whether the suspect is resisting or fleeing. Courts must judge force objectively from the perspective of a reasonable officer on the scene, acknowledging that officers often make split-second decisions in tense, rapidly evolving situations. Subjective intent, whether malicious or well-meaning, is irrelevant. The court explicitly rejected the lower court's reliance on the malicious and sadistic test used in Johnson v. Glick, explaining that subjective motivations have no place in the Fourth Amendment analysis. Instead, the inquiry is purely objective reasonableness. The Fourth Circuit's judgment was vacated and the case was remanded for consideration under the correct Fourth Amendment standard. Therefore, what you should take away from this case is that when assessing excessive force, courts must focus on whether the officer's actions were objectively reasonable, considering the circumstances confronting them at the time, rather than their intent or hindsight evaluation. This standard applies to both deadly and non-deadly force, ensuring a balance between society's interest in effective law enforcement and the individual's right to be free from unreasonable force. High-speed chases highlight the intense pressures police face and raise significant Fourth Amendment questions about the use of force. When officers pursue a suspect who is fleeing, the Constitution requires that any force used be objectively reasonable, given the circumstances at the time. Courts must balance the public's safety against the rights of the suspect, and the facts of each case can drastically affect that analysis. In Scott v. Harris, 2007, a Georgia deputy observed Victor Harris driving well above the speed limit and then accelerating despite police signals to stop. The pursuit reached speeds over 85 miles per hour on narrow two-lane roads, putting the public, other motorists, and the officers themselves at risk. After 6 minutes of pursuit, Deputy Scott decided to end the chase by forcing Harris off the road using his patrol vehicle, causing Harris's car to crash and leaving him paralyzed. Harris later sued, claiming the officer had used excessive force. The Supreme Court analyzed the case under the objective reasonableness standard. It concluded that Harris had created an immediate and substantial danger to others and that Scott's actions, although risky for Harris, were justified to protect the public. The court rejected the argument that Scott should have simply abandoned the chase, noting that doing so could have allowed Harris to continue driving recklessly and put more lives in danger. Justice Stevens dissented, suggesting that the police could have ended the pursuit safely once Harris's identity was known, reducing the risk of injury. In Plumhoff v. Rickard, 2014, the court considered another high-speed chase, this time involving Donald Rickard, who led police on a dangerous pursuit exceeding 100 miles per hour, colliding with multiple vehicles along the way. Officers fired 15 shots into his car, eventually stopping him. The Supreme Court held that the officers acted reasonably, emphasizing that Rickard's flight posed a serious risk to the public and that using force to stop him was consistent with the Fourth Amendment. A third case, Molinex v. Leija, 2015, involved Israel Leija, who fled police at extremely high speeds, threatened to shoot officers, and may have been intoxicated. Officer Molinex fired shots from an overpass, killing Leija. The court held that given the circumstances, Molinex's actions were reasonable. Leija was armed, potentially intoxicated, and presented a clear and immediate danger to the public and officers. Justice Sotomayor dissented, arguing that endorsing such a shoot-first approach risk undermining the Fourth Amendment protections. From these cases, several key principles emerge. Seizure by force. Any action taken to stop a fleeing suspect constitutes a seizure under the Fourth Amendment. Objective reasonableness. Courts evaluate whether the force used was reasonable, based on the scene, the circumstances, without the benefit of hindsight. Threat to public safety. Deadly force may be justified when a suspect's flight creates an imminent risk of harm to others. Civil liability. Officers are generally protected from liability if their actions are objectively reasonable, but debates remain over whether current standards strike the right balance between public safety and constitutional rights. And honestly, there's about 1 or 2 cases a year that are ripe for review with the Supreme Court that reanalyze the civil liability of officers. These cases collectively illustrate how courts weigh the need to apprehend suspects against the danger posed to the public and the suspect, demonstrating that the context of the chase often dictates the reasonableness of the police action. In White v. Pauley, 2017, the Supreme Court held that a police officer who arrives late to an ongoing, dangerous police action may reasonably assume that earlier arriving officers have self-identified and is not constitutionally required to second-guess their compliance with identification procedures before responding to an immediate threat. In that case, officers investigating a reported reckless driver encountered armed occupants who fired on them, and the court found that the officer who shot an armed suspect acted reasonably under the Fourth Amendment because he reasonably believed proper protocols had already been followed and was confronted with an imminent danger. The decision emphasizes that the reasonableness inquiry focuses on what a reasonable officer confronting a sudden threat would do, not on perfect backwards reconstruction of every prior step taken by law enforcement. This principle remains especially relevant in current debates over immigration and customs enforcement, or ICE, operations, where failure by some agents to clearly identify themselves before entering premises have drawn criticism and raised serious Fourth Amendment concerns about transparency and how quickly a tense situation can escalate when occupants do not know they're responding to law enforcement rather than just simply potential intruders. The Supreme Court has made clear that the constitutionality of police use of force is judged independently from other potential Fourth Amendment violations. In County of Los Angeles v. Mendez, 2017, deputies searching for an armed parole violator entered a backyard shack without a warrant or announcement and encountered occupants who were unaware police were present. When one occupant picked up what appeared to be a firearm, officers immediately fired, causing severe injuries. Although the entry itself violated the Fourth Amendment, the court held that the officer's use of force must be evaluated based solely on what they reasonably perceived at the moment force was used. A separate constitutional violation, such as an unlawful entry, cannot retroactively render an otherwise reasonable use of force unconstitutional. The decision reinforces that Fourth Amendment reasonableness focuses on the immediate threat perceived by officers, not on earlier mistakes in the chain of events. But remember earlier that we discussed officer-caused exigencies? Wouldn't it make sense to apply a similar standard to situations like these? If the officer creates the issue by violating the Fourth Amendment, wouldn't it follow that any use of force thereafter should also be unconstitutional? Think about yourself, for example. If you're sitting in your home and you choose to use a firearm for protection, and somebody breaks into your home, they don't identify themselves, and you don't know what they're doing there, if you reach for your weapon, should it be constitutional for an officer to react and open fire on you for using your firearm? These are the types of questions that scholars continue to debate and that legal professionals would like to see the Supreme Court resolve. A custodial arrest represents a significant intrusion on personal liberty. An arrest does not merely involve a brief stop, it places an individual under police control and exposes them to searches, booking procedures, detention, and the stigma and inconvenience of the criminal justice process. Even short periods of custody can be humiliating and disruptive, reinforcing the idea that, in some cases, the process itself functions as a form of punishment. This reality raises an important question in Fourth Amendment law. When an officer has probable cause to believe a minor misdemeanor has been committed, is it reasonable to make a full custodial arrest, or should a citation be the preferred response? A citation allows the individual to remain at liberty while still requiring accountability through a future court appearance, provided the person can be identified and does not pose a risk of flight or danger. Arguments in favor of issuing citations emphasize proportionality and efficiency. Arresting someone for a minor offense consumes police time and judicial resources and subjects individuals to indignities that may be unnecessary to achieve law enforcement goals. Civil libertarians also caution that broad arrest authority for low-level offenses can facilitate pretextual policing and disproportionately impact minority communities. On the other hand, law enforcement agencies argue that officers should not be required to make fine legal distinctions in the field between offenses that justify arrest and those that do not. From this perspective, clear and uniform authority to arrest simplifies decisions and may assist in identifying individuals involved in more serious criminal activity. Although the Fourth Amendment requires that arrests be supported by probable cause and carried out in a reasonable manner, it does not itself specify when officers must choose citation over arrest. As a result, jurisdictions vary widely in how they regulate misdemeanor enforcement, with some states requiring citations for certain offenses, absent special circumstances, while others grant officers broad discretion. This ongoing tension between individual liberty and law enforcement discretion sets the stage for the Supreme Court's consideration of whether the Constitution imposes limits on custodial arrests for minor offenses, a question we'll turn to with our next case. By way of example, Indiana, where I practice, allows officers to arrest individuals for misdemeanor crimes, but not for infractions. So a seatbelt violation or something like that, you certainly can't be arrested for, but you can be arrested for something like OWI as a Class A misdemeanor, or domestic battery as a Class A misdemeanor, trespassing as a Class A misdemeanor, even leaving the scene of an accident, which can sometimes be a Class C misdemeanor, which is the lowest level of misdemeanor in Indiana, can result in an arrest. However, many jurisdictions changed their take on these arrest procedures during COVID, and the reason for that was because of jail overcrowding. So jails are typically already overcrowded in most states, and in the jurisdiction in which I practiced, that was certainly the case. And so, as part of COVID protocols, the law enforcement officers in the county and city police force were advised to only arrest criminal defendants for misdemeanors that had a victim or were the result of violence. So, for example, the officers would be allowed to arrest someone for a domestic battery as a Class A misdemeanor because there was a victim. However, they were not allowed to arrest someone for possession of marijuana, which without a prior is a Class B misdemeanor. So COVID kind of changed the landscape of what some states were willing to do, but Indiana is certainly one of the states that allow officers that broad discretion in arresting for minor offenses. In Atwater v. Lago Vista, the Supreme Court confronted whether the Fourth Amendment prohibits a warrantless custodial arrest for a very minor offense, specifically a seatbelt violation, punishable only by a fine. The case forced the court to decide whether reasonableness under the Fourth Amendment requires more than probable cause when the offense is trivial. The facts were incredibly stark. Gail Atwater was stopped for failing to wear a seatbelt and for failing to secure her young children. Although Texas law permitted either a citation or an arrest, the officer chose to arrest her. She was handcuffed, taken to jail, booked, photographed, placed in a cell, and released after posting a bond. Ultimately, she paid a modest fine. Atwater argued that this arrest was an unreasonable seizure given the minor nature of the offense and the absence of any need for detention. Justice Souter, writing for the majority, acknowledged that Atwater's arrest was unnecessary, humiliating, and poorly exercised. If the court were deciding the case solely on its facts, Atwater would likely have prevailed. But the court emphasized that Fourth Amendment doctrine does not operate on individualized fairness alone. Instead, it requires rules that police officers can apply quickly and consistently in the field without engaging in complex legal analysis. The court rejected Atwater's proposal that custodial arrests be barred for fine-only offenses. Drawing such a line, the court explained, would force officers to make difficult distinctions about penalty schemes, repeat offender status, public safety risks, and enforcement needs, judgments that are impractical during roadside encounters. A rule requiring officers to default to citations when in doubt would also risk under-enforcement of the law. As a result, the court adopted a bright-line rule. When an officer has probable cause to believe a criminal offense, no matter how minor, has been committed in the officer's presence, the Fourth Amendment permits a custodial arrest. No additional balancing of interests is constitutionally required so long as the arrest is carried out in a standard manner. The majority also rejected the claim that Atwater's arrest was conducted in an extraordinary way. While conceding that the arrest was embarrassing and upsetting, it wasn't excessively intrusive. The court characterized it as no more intrusive than a typical custodial arrest and therefore constitutionally permissible. Justice O'Connor, joined by 3 others, dissented sharply. She argued that the Fourth Amendment requires a case-specific assessment of reasonableness, and that a full custodial arrest for a fine-only offense is a severe intrusion on liberty. In her view, when the legislature has determined that imprisonment is unnecessary punishment, the state's interest in taking a person into custody is correspondingly weak. The dissent emphasized that citations can typically satisfy law enforcement goals such as deterrence, identification, and court appearance without subjecting individuals to arrest, searches, detention, and permanent arrest records. Granting police unfettered discretion to arrest for trivial offenses, O'Connor warned, invites abuse, facilitates pretextual policing, and disproportionately impacts vulnerable communities. Ultimately, Atwater establishes that probable cause alone is sufficient to justify a custodial arrest for even the most minor misdemeanor, leaving questions of proportionality and restraint largely to legislatures, police departments, and state constitutional law rather than the Fourth Amendment itself. I typically try not to give you my opinion on these types of cases because I want you to form your own opinions. I want you to assess the facts and make up your own mind. However, what I would say is that from a practice perspective, I think the majority got this one wrong, stating that officers would have to make a determination between, the schemes that the state has set out for whether or not something is punishable by a fine or imprisonment really isn't all that difficult. Officers who make an arrest are going to have to state the basis of the arrest and the proposed charge against the defendant. Here in Indiana, like I said earlier, there's not really a question about whether or not an officer knows whether something's an infraction or a misdemeanor. They have to write down the specific statute in order to make the charge. So they know that by writing up a charge for a misdemeanor, it's an arrestable offense. They also know that if they're just issuing a ticket, they can't arrest somebody for that. It doesn't seem like a far stretch for officers to have to make that decision or assessment in the field when they're already going to have to make a charging decision anyway. But again, that's just my opinion and my experience in the state of Indiana. I don't practice law in the state of Texas, and their scheme might be more complicated. And the Supreme Court does have to make the rules to apply to every state, not just the state I'm practicing in. The Supreme Court has made clear that a traffic stop is a limited seizure whose duration must be tied to the purpose of the stop. In Illinois v. Cabeas, the court held that a dog sniff conducted while an officer was still completing the tasks associated with a speeding stop did not violate the Fourth Amendment because it did not extend the stop beyond the time reasonably required to issue the warning. The court refined this principle in Rodriguez v. United States. There, an officer completed all tasks related to the traffic stop, checking documents, running records, and issuing a warning. But the officer continued to detain the driver to conduct a dog sniff without his consent. In fact, it was approximately 8 minutes between the time that Rodriguez had been issued his citation until the time that the police dog alerted. The court held that a traffic stop functions much like a Terry stop and must last no longer than necessary to address the traffic infraction. Once the mission of the stop is completed, the officer's authority to detain the driver ends unless additional reasonable suspicion develops. Routine checks, such as verifying a driver's license, registration, insurance, and outstanding warrants, are considered part of the traffic mission because they promote roadway safety. A dog sniff, however, is aimed at uncovering unrelated criminal activity and may not be conducted if it adds time to the stop. The constitutional question is not the order of events, but whether the officer prolonged the stop beyond what was reasonably necessary. The court remanded Rodriguez to determine whether reasonable suspicion justified the extended detention of Rodriguez. However, think critically about this. Given the decision of the Supreme Court here in Rodriguez, what would prevent an officer from just taking an extended amount of time to do all of the necessary traffic functions if he'd already decided he wanted a dog sniff conducted? If he knew that his partner with a dog was 10 to 20 minutes out, why wouldn't the officer take an additional minute or two to check the documents and then another minute or two to check the license plate and the registration, the insurance documents, to write up the ticket? By that point, the dog could already be there. Some scholars argue that Rodriguez prevents this because it states that the officer cannot prolong the stop. But if they're engaged in what's considered reasonably necessary, does it matter? Just food for thought. In Virginia v. Moore, the court addressed whether an arrest violates the Fourth Amendment when state law authorizes only a citation. Moore was arrested for driving with a suspended license, and a search incident to that arrest uncovered drugs. Although Virginia law required officers to issue a summons rather than make an arrest, the Supreme Court held that the arrest was constitutionally reasonable because it was supported by probable cause. The court emphasized that Fourth Amendment standards do not depend on state arrest rules. When officers have probable cause to believe a crime has been committed in their presence, the Fourth Amendment permits a custodial arrest and a search incident to that arrest, even if state law prefers a less intrusive enforcement option. However, I did go through and read the history of Virginia v. Moore and how it made its way to the Supreme Court. Virginia v. Moore came up to the Supreme Court after making its way through the entirety of the Virginia state court system. And the issue here is that Moore's defense attorney and appellate attorney argued for Fourth Amendment protections under the United States Constitution. And because they did so, I question whether or not Moore would have had a better result if defense counsel and appellate counsel would have argued under the Virginia Constitution. Remember, states can provide more rights than the United States Constitution, just not less. In this instance, the appellate counsel made arguments under the United States Fourth Amendment. And I wonder if the argument had been raised under the Virginia Constitution and its Fourth Amendment equivalent, would the result have been different? Never know. In conclusion, a lawful arrest requires probable cause and reasonable execution. Probable cause is more than reasonable suspicion, but less than proof beyond a reasonable doubt. Officers may rely on observations, senses, and hearsay to establish probable cause. Informant tips are analyzed under a totality of the circumstances approach. Warrants require probable cause, oath or affirmation, and particularity. Warrantless arrests in public are generally permitted with probable cause. Arrests inside the home usually require a warrant unless exigent circumstances exist. Both deadly and non-deadly force are governed by Fourth Amendment reasonableness. And courts evaluate force from the officer's perspective at the moment force is used and independently of other Fourth Amendment violations. I'll see you in Chapter 6. And thanks for hanging in there. I know this was a long one.